Ask.
Are you prepared to perjure yourself? Okay, it's nice that, I'm glad I didn't
That's
take
not
a
a proper
360.
question. I'm going to determine that Ms. Bridgman is elected that she doesn't want to ask.
Okay,
Mr. Gilbert
let me ask him.
She just wants to rail against him. Mr. Gilbert, you can step down. Thank you.
Yeah, how do you ask questions of when you've all cooked this all up between yourselves?
Ms. Miller, your next witness.
Your Honor, I don't have any further witnesses in this matter.
Okay. And the court will take judicial notice of its own files and the transcript of the arraignment on November 30th, the transcript of the order to show cause on December 21st, and on the failure to appear. The court will take judicial notice of Ms. Bridgman's returning the order to show up, the order to appear, cut into strips with the writing of offer to contract is not accepted, as well as the statements that she made at her arraignment on the bench warrant. All right, so Ms. Bridgman,
So this is
do you have any witnesses that you wish to present?
I have to say that even being here today and putting myself and submitting myself to your authority that has not been substantiated goes against the one and living God that I respond to. You cannot ask me.
Okay, so I've given you an opportunity.
Does anybody want to go stand on what happened that day? But I don't want anybody to enter your jurisdiction, Your Honor, because,
so you're not
okay,
calling
my honor. Let's do it this way.
Hang on. So so I've offered you an opportunity to call witnesses and you've elected not to. Closing arguments, Ms. Miller.
Your Honor, I'd ask that the court find Ms. Bridgman in contempt for for interfering with Mr. Flores' arraignment from the MIDC and engaging in unauthorized practice of law. There was testimony that Mr. Flores didn't know Ms. Bridgman before he entered the courtroom the courthouse on the 30th, that she approached him, that she was with him when she was with him in the courtroom. She told him that he didn't need a lawyer. She was providing legal advice to him, saying that he didn't need to, he was driving his personal vehicle and he didn't need to engage with the process. He testified that she told him what to write on the ticket to provide to the court. I asked the court to take judicial notice of the ticket with Mr. Flores' writing on it. He testified that once he turned it in, he was advised to leave the building by Ms. Bridgman before he had his arraignment.
Wow.
So I would, and then further the testimony of Mr. Gilbert, that he was the arraignment attorney, that he was in the courtroom when the judge indicated that Mr. Flores should meet with him. He testified that Ms. Bridgman interrupted him 3 times from meeting with Mr. Flores, that he tried to but wasn't able to. He wasn't able to advise him of his rights or to go over the ticket with him, and further that Mr. Flores left without being arraigned on the matter.
Is it still possible to object to all these presumptive evidences? You brought your own people in who are on the county payroll.
It's closing argument. Go ahead. You have your chance.
And I would ask the court, I think it's clear that Ms. Bridgman was interfering with Mr. Flores' meeting with the arraignment attorney by physically preventing Mr. Gilbert from meeting with him, further telling him what to put on a piece of a document to submit to the court on his behalf. That would also be engaging in giving him legal advice. So I find I'd ask the court to find her contempt on that, and I'd also ask the court to find her contempt for failing to appear on the show cause that was issued to her on the 20th of December. Thank you.
All right, thank you. Ms. Bridgman, now's your opportunity to make any closing argument that you wish. Go ahead.
I am not in this hearing situation. This has been conducted as what is called a star chamber. As all of our founding fathers left because the Bar Association members are arraigned against a witness and they have no due process. Has anybody here not witnessed a breach of public trust and due process?
Yes.
Yes.
Well, people could judge for themselves. We've conducted a hearing. People can testify.
It's not a hearing, it's a witch hunt.
Hang on. No.
There was no...
Conclude your closing argument. All right. Any further outbursts?
The speaker argues that being a member of a bar association is not the same as holding a legal license. They claim the judge is not listed through the state's licensing system and suggest that legal professionals have obligations to one another that they believe conflict with protecting individual rights and due process. The speaker goes on to criticize how the courtroom is being run, saying they believe the process is unfair and that law enforcement officers are simply carrying out the court's decisions without enough consideration for the people involved. They also questions the judge's oath of office, claiming it was not completed correctly. According to the speaker, an oath should be administered by another authorized person before it is notarized. They argue that a person should not sign their own oath and have it notarized without someone else officially administering it, stating that the process should involve 3 people: the person taking the oath, the official administering it, and a notary.
And not to follow the unalienable rights of the people and due process.
It's the people's court.
This is not, you have just set up a star chamber and you've got guys with guns ready to carry out whatever you want, and you have not even taken enough care about the people and your situation in the court to execute a proper oath. You should have had somebody swear that oath to you. You can't sign your own oath and have it notarized. You did that with the prosecutor. You have to have somebody who swore you in signing it and then a notary. It takes 3 people. I should not be submitted. If somebody is practicing law without a license, it's all of you Bar Association members.
Yep.
No, there is no license. It's a private membership. And I cannot subject myself as a living soul to an authority that violates my God-given unalienable rights. And if you gentlemen carry that out, have you any idea what you're doing? What you're being asked to do? You need to think about it, because I can tell you right now, our military is watching every move you make right now. This is your opportunity to stand for the people and not for the people that are trying to steal every one of our rights as they did with Seth Flores. You should be ashamed of yourself, Deputy Dukowski. You told him on his second MIP you were going to take his vehicle and he was going to have to pay $12,000 to get it out of the impound. Do you know how many friends I have that can't drive a freaking car in this county up until the age of 35? I don't practice law. I practice rights. I practice people living free and supporting one another. So if your court finds me guilty, your court is finding every God-given right the universe has ever known to be a fraud. We would be happy to administer the real oath for you today, Judge Gaffia. We have a body of people. We would be happy to do that. We need a district court judge for the people to reinstate common law. The Bar Association has bought out the entire state of Michigan for the CCP. I know what that means. I know what your role in that means. And I believe redemption is for everyone. Amen. And I could be your best friend to make, I believe you know God's truth. I believe you want to do God's truth. And I believe you could be the man that we need. Amen. But we have to leave this process of the Bar Association, and you have to take an accurate oath.
I'll witness it.
I'll witness it too, out there.
All right, thank you, Ms. Bridgman. And now I'll make the ruling. Article 6 of Michigan's Constitution of 1963 vests the judicial power of the state of Michigan in the Supreme Court and courts of record as established by law. It also gives the Supreme Court superintending control over all the lower courts. Michigan's Constitution also provides for the passage of public acts passed by the legislature and approved by the governor. These statutes, despite bad information that people get online, have the force of law. Michigan has a statutory system regulating the practice of law. Michigan Compiled Law 600.901 through 949. Section 904 vests the Supreme Court with the power over the state. Ms. Bridgman, you may not leave the courtroom.
I'm going to talk to somebody. I'm not trying to get away, Dukowski. You won't see me at 3 a.m. on Butler Road.
I'm giving my ruling here.
Okay.
Section 904 vests the Supreme Court with power over the State Bar of Michigan, which under Section 901 is a public body corporate consisting of all persons licensed to practice law in Michigan. Section 916.
The discussion explains that people who identify as sovereign citizens often criticize the legal system while overlooking that many common law principles were developed through court decisions over time. The speaker then emphasizes that one of the main reasons for regulating the legal profession is to protect the public from individuals who provide legal advice without the necessary qualifications or training. Next, the speaker addresses the question of what legally counts as practicing law. They refer to a 2003 decision by the Michigan Supreme Court, explaining that a person is considered to be practicing law when they advise or assist someone on legal matters that require professional judgment and legal knowledge.
The common law of England. When so-called sovereign citizens complain about the common law, they neglect to notice that the common law was what courts said.
Codes and
This
statutes
regulation is
are not
rooted in the
law.
importance of protecting the public from the danger of unskilled persons practicing law.
Oh my goodness.
What constitutes the practice of law? In Dressel v. Ameribank, the Michigan Supreme Court in 2003 held that a person engages in the practice of law when he counsels or assists another in matters that require the use of legal discretion and profound legal knowledge.
So, Your Honor, where
Now,
was
basic
that
free
in my
speech
latest
protection
charges?
Protect the right of people to espouse beliefs and to tell other people about those beliefs.
Ryan,
So Ms. Bridgman has the free speech right to believe what she wants to about courts and government and to tell other people about that. This includes, of course, criticism of government and of the courts, but to give advice, guidance, and assistance to another person in their own legal matter at the courthouse to be applied to their particular case at that time crosses the line into the practice of law. At its heart, the practice of law is applying legal knowledge to a particular issue or problem. This unauthorized practice of law is a contempt of court.
you had that written up earlier, didn't you?
Additionally, interfering with someone meeting with their attorney is a disruption of the court process and is therefore also a contempt of court.
He was not there to
The
meet
primary
his
purpose of
attorney
the
yet.
contempt power is to preserve the effectiveness and sustain the power of the court. The power to hold a party in contempt is inherent in the judiciary,
So,
yet still the legislature has recognized this and codified it. This is merely a recognition of the common law contempt power of courts. Among these statutes, Section 600, Section 1701H provides that any court of record may hold in contempt all persons for assuming to be and acting as officers, attorneys, or counselors of any court without
oh,
authority,
good Lord.
or for other unlawful interference with or resistance to the process or proceedings in any action. So interfering with a person's consultation with an appointed attorney as directed by a judge interferes with that process in that court case and is a contempt of court.
But I tell
Let's just
you,
pretend.
There are two
Doesn't even
forms of contempt, civil and criminal. Civil contempt applies when someone refuses to obey a court order and the court coerces their compliance. So in civil contempt, the person can contempt by obeying the order. Criminal contempt
you
applies
guys
to
put
past
hands on me today.
for failure to appear as a criminal contempt.
Be careful.
The court, Ms. Bridgman, you've had your, I've given you every
Aaron, you are
opportunity.
misbehaving. You had this prepared. You
I
looked it
am.
up with your witnesses. Come on
The Court
now.
of Appeals has specifically.
I was not
held
practicing
criminal
law.
contempt is-
I was practicing rights. Common law and the Constitution is about rights, not law.
The woman responds by saying, "I do not accept your offer to contract," and claims that officials entered her property without permission. The judge then explains that the court has the authority to require people to appear for scheduled proceedings. The court finds that Ms. Bridgman is in contempt for disrupting the proceedings and for allegedly engaging in the unauthorized practice of law during an earlier hearing on November 30th, 2023. The judge also states that she is in contempt for failing to appear as ordered at a later court date. During the exchange, the woman makes a remark about knowing jiu-jitsu, prompting the judge to caution her to be careful. The hearing then continues as the judge refers to the scheduled court dates and clarifies the timeline.
Codes and
He
statutes.
was not authorized to do so. And that resulted in harm to Mr. Flores. He was in jeopardy of contempt of court by leaving without finishing the arraignment process by
My
following
honor.
the bad advice of Ms. Bridgman.
I am not
That was
wanting to be in
court
contempt
by
of court.
practicing law. It's a contempt of court for interfering with the court process. Ms. Bridgman is also in contempt of court for failing to appear for the show cause hearing when she didn't show up for it, but she instead beforehand turned in the order, cut up into little pieces with the statement, your offer to contract is not accepted.
You trespassed on my yard with
Courts have
no,
the inherent authority to
Right.
compel attendance, and she is in contempt of court for doing that. So Ms. Bridgman is in contempt of court for unauthorized practice of law and for the interfering with the court process on November 30th, 2023. She's also in contempt of court for failing to appear
oh,
for her show cause hearing.
Better be careful, I know some jujitsu.
What day was that scheduled for?
Oh, I remember.
On December 20, I'm sorry.
I'm gonna pull you behind. So, my honor,
So she's in contempt of court for failing to appear on December 20th. All right, Ms. Miller, any allocution as to sentence?
Your Honor, just, it's concerning whenever a person is not able to, participate in the judicial process in accordance with their rights. So I think that's the biggest issue. Is that Mr. Flores, wasn't able to meet with MIDC, left without being arraigned. So I just asked the court to keep that
that's right.
in its, consideration when issuing a sentence.
All right, Ms. Bridgman, do you have anything you wish to say before the court pronounces sentence for the contempt?
Under common law, which is the only true law because comes from God's natural law, and the Constitution is based on that. The Constitution is not about law, it's about rights. I was not talking to Mr. Flores about any legal thing because I'm not a bar association lawyer. I don't know about all your laws. I do know that the need to have a attorney at arraignment, from what State Trooper Brenda Casperson told me, only started a year ago. That is codes and statutes. We are not bound by that. We are living beings. We are not the corporate dead entity of the court system. I did not practice law. I practiced his rights. Do you know there are plenty of other counties in this state that accept that same documentation that I filed and had Seth file? I was hoping to make him unafraid of all of these. He has good things to say about a couple of your deputies. They're not all like that. This court is for profit. So standing in the way of that attorney, but that testimony, Mr. Gilbert, you should be ashamed of yourself, was not truthful. You had never approached.
All right, Ms. Bridgman, this is your opportunity to tell me what penalty I should give you, if any.
Was anybody harmed?
Closing argument.
Was there any other financial damage to Seth Flores? I know there was to Mr. Gilbert because he lost a client that day, but then he recovered that. Good. Okay. Are we not allowed to talk to people in the courthouse, not in the courtroom? Is that not a public space? Are we not allowed to help a fellow citizen understand that he doesn't have to lose everything in his life as he's just getting started? That he can have people stand with him and encourage him and coach him through, maybe handle his drinking. I suggested that he stop drinking and he start to, pay attention, and we'll be there if he gets pulled over because he's afraid. I don't see where there has been any harm. And if you can rule that is contempt, I have no longer I see no ability to redeem anything in this courtroom. You refuse to address your oath. And if you hold me in contempt of court, I think that's Quite unbelievable.
Absolutely.
All right, well, I've already
Yeah,
so
but
have.
I do have somebody who would like to make a statement on my behalf.
No, that's not allowed. All right, so, I have
See,
filed
you're
a.
judge,
I-
jury.
Yeah, you've made all your statements. I have filed an oath proper under the laws. I filed the constitutional oath required by Article 1, Section 11 of the state